What's going on, everybody? Hope you're having a good week so far. Happy hump day. Honestly, Skyrim's intro music is probably the best. I have a hard time. Oh, it's on looping. I have a hard time believing that there's something out there better, but it always gets me hyped up. Anyway, welcome everybody to part 2 of this endeavor. We're going to be starting off where we left off, which was we were in the middle of the second hearing. The second pre-trial hearing, the one right before trial. And oh, those of you who are asking, I'm feeling fine. I'm back to normal. I've been back to normal for almost a week now. No, actually, as a matter of fact, it's been a week since I've been back to normal. That's right. So yeah, all good. Appreciate it. The family's fine. If you didn't know, if I didn't already say, the whole family is all recovered. Everybody's all good. So yeah, like I said, we're gonna have part 2. We're also gonna be playing some Skyrim. I actually, I'm gonna get so many rolled eyes right now. But I felt like as much as I like the mod list that I chose, I feel like it's just too brutal, and I just want to be like very laid back with my Skyrim. So I basically cleaned the slate and downloaded a brand new mod list. This time it has a lot of the good stuff though, and as in like Legacy of the Dragonborn and a lot of other modded quests that were omitted from the mod list I was using beforehand. Further, it allows me to do a vanilla start, which I've actually missed doing. I miss doing the meme of hey, you're finally awake type of meme. So we're gonna take a look at that too. Shut the hell up, Omega. So we're gonna do that. Like I said, this is a very visual. The actual meat of the stream is almost all of its audio. So just sit back, relax, take a listen if you don't care for a 10-year-old game. No, 11-year-old game. Oh my god. The game's 11 years old. All right. Let's get started. I already noticed everybody in the chat, okay? So hello everybody.
Then let's move on with that.
I'll respond to whatever he brings to the court, Your Honor. Now, Your Honor, Mr. has been requesting discovery. I have discovery prepared to hand him. He'll need to sign for it, showing that he received it. He has sent a lot of discovery pursuant to civil procedure, interrogatories, admissions, disclosure. Those are civil procedure. These documents are provided pursuant to Article 39.14 of the Code of Criminal Procedure. And that's the only discovery that the Wood County District Attorney's Office intends to give him. It's not proper that you ask for all these discovery requests pursuant to rules of civil procedure in a criminal case. But I have these documents provided to him. He'll need to sign for them. And there's one other thing, Your Honor. There is a video recording of the officer's stop. There's a dash cam and a body cam. Both of those are on one disc.
Man, I really hate the fact that we can't see either of them. Yeah, the prosecutor just said that there's both a dash cam and a body worn camera footage of the traffic stop, but this guy didn't get a copy.
Those are at the DA's office, the Wood County DA's office, pursuant to 39.14 subsection D as in dog. That disc will not be provided to him, but it is available for him to review. He will simply need to call Mr. Jerry Hirsch at the DA's office, make an appointment, and they'll set a place and a time for him to view that video. So that's also in the discovery.
Do you need Mr. Hirsch's phone number?
No, ma'am. I won't be visiting Mr. Hirsch, but thank you.
So I'm providing this to you, Your Honor, as a copy, but if he will sign it, if he won't, I'll put refuse to sign, but we are going to provide these to him this morning.
Thank you. Where would you like a signature?
That page and the next page.
Are these little?
These are my copies, if you want to sign that too.
I don't know what all this fine print is, and I don't trust you, so I'm not going to sign the second one. But you can have that first one.
If you put a date on there.
Date received October 6th.
Yes, sir.
That's my copy, but if you'll sign it, if not, I'll make a copy of this first page.
That's my Your Honor, I would like to just reference one thing. He's talking about discovery as if 39.14 is the only thing that I could have, and he's incorrect. I don't know if he's doing this on purpose or if he's just incompetent. I have no way of knowing, but 3906 speaks to the interrogatories that I did request, and I actually mentioned that 3906 in my request, my discovery request. So I don't know where he's getting this idea that 3914 is the only thing he can respond to. Also, the footage, I would ask that Your Honor order him to give me that footage, the video and the audio. No reason for him to just keep it from me. And it sounds like he intends to have me jump through some more hoops, drive to some other city and meet with somebody to not get a copy of it. And there is a provision in 3914, which I guess he's assuming that this court is going to order, and or he didn't even ask for it. Why should I bother to try and help him? But in 3914, there is no mention of a defendant can't have a copy, except if this excuse me, if this court orders that the defendant should not be allowed to have a copy but only inspect. Well, this court did not make such an order, and he didn't even move for such an order. I don't know why he would. There's no grounds. Why would he keep something like that from me? I think it's only fair that he provide all the evidence that he thinks he has.
If our DA's office wanted to release that, where would you want it sent? But I can't guarantee you that they'll release a copy of it.
Yes, ma'am, the same address that's on all of my pleadings here.
We're gonna get with Mr. Thomas and his staff.
Okay, fair enough, thank you.
Judge,
Could you
briefly address, he's talking about interrogatories at 39.06.
Yes, sir.
That's not correct. The written interrogatories are in a deposition. He has a right to move for written interrogatories in a deposition, and he hasn't done that. So that's not part of the discovery of 3914. 3914 talks about a pro se defendant. If the court orders the state to produce and permit the inspection of a document, item, or information under this subsection, the state shall permit the pro se defendant to inspect and review the document, item, or information, but is not required to allow electronic duplication of that document. So, Judge, the code, if you order it, we'll do it, but the code prohibits us from giving him a copy of it. And we're not
if
gonna-
Your Honor orders that?
If you order him the opportunity to view it, but he didn't get a copy of it, but if you.
We did tell him where he could view it.
Okay.
Well, Your Honor, he's conflating a couple of things here. He's making it sound like that the default is that if there is no ruling, that the defendant would not be allowed to have a copy, and it doesn't say that. Instead, it says that if the court orders inspection only, then they better not give me a copy. So let's look at 3906 here. I would like to just read and ask this court to take judicial notice of Code of Criminal Procedure 39.06. When any such deposition is to be taken by written interrogatories, that's exactly what I'm trying to do, is to take a deposition that's the easy way, the cheap way, not trying to get it complicated and involved and having people deposed, you know, the more complex way. I'm trying to do this the simple way, which is by written interrogatories. And it says here, such written interrogatories shall be filed with the clerk of the court, which I did, and a copy of the same served on all other parties or their counsel, which I did, for the length of time and in the manner required for service of interrogatories in civil action. It references civil action is how we do it here too. That should be a given. It should be obvious anyway, but it doesn't leave it up for interpretation. It specifically says, yeah, the way we do it in civil is the way we do it here in criminal. So I'm asking interrogatories for the purpose of judicial efficiency, for the purpose of narrowing the issues that need to come before this court. If I can narrow those by getting them via discovery, then things become more simple, more streamlined. We don't have to have as many hearings. We don't have to spend as much time listening to him say things that don't matter. It can go very fast and easy. So that's what the interrogatories are about, and that's what it specifically says. He can't deny that this fits criminal or that it fits this particular case. It doesn't say anything that takes that away from me.
Watch the
Just skips over the main
carriage
word.
keep on spazzing out.
And that main word is deposition. When any such deposition is to be taken by written interrogatory. You can take a witness's deposition by written interrogatories. This isn't, he's not taking the deposition of a witness. He's sent those to the attorneys, to the Wood County District Attorney's Office. He's not asked to take the deposition of a witness. So that's what this article applies to, depositions of a witness by written interrogatories. So it doesn't apply in this case where he's not deposing a witness.
Your Honor, two things. I agree that Mr. Thomas is not a witness, not by a long shot. And
Yeah.
I'm not
So if he's not a witness, why are you demanding he do interrogatories?
supposed to serve the witnesses here. It specifically says for me to serve the clerk of the court and to serve the counsel. It doesn't say serve the witnesses. I would have served the witnesses happily, but that's not what the rules ask me to do. And I would also draw the court's attention to 3904,
Hey, well do.
which says applicability of civil rules. Now he wants to act like depositions can't happen here, or somehow that this doesn't fit. Maybe he's never done it, I don't know. But 3904 says the rules prescribed in civil cases for issuance of commissions, subpoenaing witnesses, taking the deposition of witnesses, and all other formalities governing deposition shall, as to the manner and form of taking and returning the same, and other formalities to the taking of the same, shall govern in criminal actions when not in conflict with this code. Here again we have a very specific and very clear-cut instruction that says we're supposed to use the civil rules. Just like it's civil, we're doing the same thing here. 3904, Your Honor.
Again, Your Honor, 3904 is very specific. It says the rules prescribed in civil cases for issuance of commissions, subpoenaing witnesses, taking the deposition of witnesses, and all other formalities governing depositions, they apply. I'm not arguing that. But he's not taking the deposition of anybody. He's not requested the deposition. These don't apply because he hasn't made those requests, Judge.
So what they're saying, and what he's not understanding is that in order to issue interrogatories, he needs to first announce that he wishes to depose a witness first. Then he would send the interrogatories to the witness, likely before the actual deposition. But even then, he's still he's sending these interrogatories to the attorney, who's not a witness to the case.
Your Honor, I have requested that this deposition be via written interrogatories, and if you like, I can read that to the court. which was served to the court clerk and served to Mr. Thomas here, exactly as the rules say that I should. Would you like for me to read those interrogatories?
We don't have that in our file.
Okay. Thanks. I'll find it here in just a moment.
While you're doing that, we're gonna take a 5-minute recess, okay? So you can get.
Yes, ma'am. Okay. Thanks.
If anybody has to use the restroom, go to the left, and then one left, okay? Yeah, if you go back outside, you're gonna have to go through the process of being wanded again. You want something cold?
Yeah, he did.
Get it? You want something to drink? Anybody else want something to drink?
Yeah.
Go out the door to the left, ma'am, and the refrigerator in the right.
You said to the left, Judge?
Yes.
Okay. Next. Let's see what I can do next. Let's see what he has. Let's see what he's got. Nothing. That's for me. For me.
The next one from him is gonna be nothing.
Nothing.
Okay, I'm not sure how much dead air is going to be in this. Hold on.
I like that paper clip. I like that kind of paper clip.
Charging instrument is sufficient. And what else did you have, Mr. Fountain? You had a list of things that you wanted to ask questions about. One of them was venue.
Right. Well, before we get to venue, then there's the issue of jurisdiction.
Oh my
And,
God.
This court has to follow the due process of law in order to have its jurisdiction invoked, obviously. And Mr. Thomas here hasn't filed anything into the record. Zero. Nothing. So he referenced a moment ago that there is a provision that allows for certain documents to be filed electronically. One of those is an indictment, one is an information, those can be filed electronically. A complaint can be filed electronically, no problem, or any charging instrument. However, a complaint, the only place that a complaint would fit as a charging instrument
Oh,
is if
God.
we were doing some kind of municipal code violation thing here.
Oh, now here's the next angle. Here's the freaking next angle. Now he's saying, oh, a complaint can only be a charging instrument, even though he originally said that a complaint can't be a charging instrument. Now he's saying a complaint can only be a charging instrument if there's a municipal code violation. And he's going to argue that the speeding offense is a state violation.
And that's not going on. We're talking about a crime. He's trying to accuse me of criminal activity. The law is very clear about that being indictment or information. So, yes, it's sufficient as a complaint, but it doesn't make the complaint be into something that it's not. I can't make it into a chili recipe if I want.
Oh my God, I hate when he does these stupid ass analogies.
It's only a complaint. It's perhaps Your Honor has found facts in this complaint that I didn't see any facts. It didn't look like one evidentiary fact was listed. I don't have anything to respond to, even if a complaint were a charging instrument in this case, which it's not. But if it's a legitimate complaint and it's perfectly sufficient, which I continue to contest its sufficiency based on its lack of evidentiary facts, there's nothing asserted. But even if it's a legitimate complaint, that doesn't somehow make it into something it's not. We can't say that it's a Chilton manual for fixing somebody's truck, even if it's a legitimate complaint and it has everything it needs to be a complaint. That doesn't make it into some other document. The
It's not
document
trying to
that's
be.
needed here that Mr. Thomas and Mr. Sawyer and everybody in that office has failed to file is the indictment or information.
They don't have to. They've demonstrated it over and over and over again. This has been relitigated at least 3 or 4 times, if not more, already spanning 2 hearings. And here we go
It
again.
doesn't exist, Your Honor. So there's no place for going anywhere further with this. If they're going to end on saying all we've got is the complaint, then what are we doing here? But I do have some pretrial issues here that are already before the court, and it would be good to get a ruling on these. One of them is the challenge to jurisdiction. That's the first threshold issue. And as Your Honor, see, you have that motion there before you. It says special appearance and lack of invocation. It was from the September 4th, Your Honor. Okay, so I am, in this document, I am raising the issue that there's no controversy before this court. Whether it's a valid complaint or a valid chili recipe, this court's jurisdiction has not been invoked. And there's one way to do that, and they failed to do that.
I don't know, guys.
They didn't
Stormcloak or
invoke this
Imperials?
court's jurisdiction. Now, on the
Let me know in the
20th,
chat. Stormcloak or Imperials? Which
Mr.
one?
Thomas here, who, again, had no right to even be speaking and testifying at all, but he did testify to territorial jurisdiction. Well, I'm sorry, but that's not enough. Territory
God.
doesn't convey everything that's needed in order to get into this courtroom. There has to be some
my God, it's pretty
evidentiary facts
even.
that lead to probable cause to suspect that a crime happened, and that
Real,
crime would
real.
have to be a finally misdemeanor.
Oh,
Or he would have to allege some
All right, looks like Imperial's
code
winning.
violation or some county code violation, I'm sorry, that would be heard in this court. None of that has happened. He didn't allege anything. So my special appearance and challenge to the lack of invocation, I'm not saying this court has no jurisdiction ever to hear anything. I'm saying whatever that would be was not brought before this court. He didn't file anything. So we know that the primary pleadings, as discussed earlier here, that the primary pleadings, Code of Criminal Procedure 2701, clearly says, the primary pleadings on the part of the state shall be an indictment or an information. And regardless of whether the complaint is sufficient, it's not an indictment or an information any more than it's a chili recipe. It's only a complaint. And we see in the Code of Criminal Procedure 21.22 that the complaint is supposed to be filed along with the indictment or information. When the district attorney's office, Your Honor, follows the due process and they see 2.05 commands them to draw up based on this sworn complaint, which that one wasn't sworn either, but they have to take this sworn complaint and say, I'm going to draw up an information based on that complaint. Both of those documents, per 21.22, need to be filed together. Regardless of whether they're allowed to be filed electronically or not, there is zero place for the complaint to just say, oh, we got the complaint, that's enough. We don't need the indictment or information. That's faulty, Your Honor. There's no place in law that says that. So they haven't commenced a case, even if a non-party e-filed something. Non-parties shouldn't be allowed to e-file anything, but we'll leave it at that.
But he's the attorney acting on behalf. Oh my god.
Mr. Thomas?
Judge, I'm a little confused. You've already ruled that the charging instrument was the complaint, yet we're still arguing about that.
No, she ruled that it was sufficient as a complaint.
The complaint is the charging instrument.
Oh,
Your Honor,
God.
is he going to testify again?
Oh my god.
Object.
Shut up.
You've denied his request to say that the charging instrument was not effective. You've said the complaint is the charging instrument, but we're still arguing about that.
Have you
We're
issued
gonna-
that ruling?
Yes, sir.
Oh, on what grounds?
What are we wanting to go to the venue now?
No, ma'am. On what grounds did you issue the ruling that a complaint is a charging instrument?
I thought she already did that.
He doesn't get to ask the court questions. I mean, you.
I thought she already did that beforehand.
Object to them and
I already told
In-
you.
in part one.
I'm not
So-
trying to be mean.
No grounds.
You can appeal it to the higher court if you want.
Okay.
Judge, if we're to the jurisdiction issue, I direct the court to the Code of Criminal Procedure, Article 4.01. What courts have criminal jurisdiction? There's a list of 15 courts in that subsection there. Number 9 is justice courts. So justice courts have criminal jurisdiction.
I agree, Your Honor. It just wasn't invoked.
I'm continuing.
Still
here.
going? Okay.
Article 4.11, jurisdiction of justice courts. Justices of the peace, subsection A, justices of the peace shall have original jurisdiction. That is original jurisdiction, Your Honor, in criminal cases punishable by fine only. That's a Class C misdemeanor. That's where we're at in this case. It's a speeding ticket. Justice courts have original jurisdiction in those charges.
I agree, Your Honor. I have no problem with that. The only issue I have, I'm raising an exception to the fact that he's pretending that a complaint is the charging instrument, and I raise an exception to the judicial error in going along with that idea. But that's as far as we'll go with that. I don't know. We don't need to talk about this anymore. He's rehashing what has already happened.
I agree, Your Honor. We're rehashing a lot of things here. This court has, let me back up. In our prior hearing, I made the statement that subject matter jurisdiction and personal jurisdiction may only apply in civil, and that would have been wrong there. But jurisdiction is the big umbrella, and we have to prove that we have subject matter over the subject. 4.11, this court has subject matter jurisdiction over all Class C misdemeanors. You have subject matter jurisdiction, you have personal jurisdiction over Mr. because of the complaint, the charging instrument that was filed, alleging he committed the offense of speeding. So that is the personal jurisdiction. Where he's talking about territorial jurisdiction, well, in Texas, we call that venue. And venue is to be decided in the court where that crime or where that violation occurred. The citation clearly says he was stopped for speeding on Highway 80, and it even gives the milepost. It's within your venue, it's within your territory. That covers all three aspects of jurisdiction.
Your Honor, I
The court
object.
has jurisdiction.
I object to Mr. Thomas testifying as if this court doesn't understand what jurisdiction means. It's insulting, it's demeaning. Everybody here knows what jurisdiction it means, and it's inappropriate for him to try to insert venue in there and equate venue equals territorial. That's not proper either, and I object to that. He shouldn't even be talking at all. So, yeah, he doesn't have personal jurisdiction. He doesn't have subject matter jurisdiction. This court would have subject matter jurisdiction, as he has highlighted, if due process had been followed to invoke this court's subject matter jurisdiction, and this court would have in persona personal jurisdiction if he had his office, which I'm not even sure it's his office, if somebody had properly served process. They didn't serve anything, Your Honor. So I mean, there's no invocation of either of those important legs to jurisdiction. They didn't do it. They can't just talk about it and pretend like it happened, and therefore you would have it. You would have it, Your Honor. This court would have it. I agree, if they had followed due process on those two important points that they failed completely, did nothing, zero. So it doesn't happen magically, Your Honor.
The citation was issued in Wood County, so the jurisdiction is gonna be proper. Okay. What's your next one that you?
All right, if you missed that from the judge, she's like, this thing was, the incident occurred in Wood County. We're in Wood County, so jurisdiction is proper.
Your next point.
Okay, I raise exception to the fact that we're going with only territorial jurisdiction without any evidence to show the other two. Let's see.
They already established that this is a justice of the peace court that can hear this type of case, so we already have subject matter jurisdiction as well, and we're good to go.
I'd like to give this court notice right now of my intent to petition for an interlocutory order on that point.
Yeah?
I feel like it's an important point to presume jurisdiction just by fiat. I think that needs to be addressed. So I'm going to just give you notice that I'm going to do an interlocutory order for that. And I raise an exception to the charging instrument. Again, we have...
You already said that.
That's a due process abrogation. And I would like to give this court notice right now of my intent to petition for interlocutory order about that issue as well. Just presuming the case existence absent any charges. Okay, so onto venue. I do have an objection before the court that the venue is improper, and the grounds for that are because the jurisdiction of this court, Mr. Thomas has utterly failed to invoke this court's jurisdiction. The fact that this court sits here and exists doesn't automatically absolve him of all of his duties to follow due process. He didn't do anything, and I object because venue is dependent on jurisdiction. Not only on territorial, but on all three. If the jurisdiction of this court had been properly invoked by due process, then subject matter would exist, personal jurisdiction would exist, territorial would exist, and I would have no objection to improper venue. But since he failed to do so, he's just trying to pretend everything, then there's nothing for me to respond to. There's also nothing for this court to adjudicate.
Okay, apparently Danny and I are fighting. We are at an impasse right now between Stormcloaks and Imperials, and trying to adjust to that, but we'll see what happens. I'll keep you guys informed.
There are no facts here, Your Honor. Nothing has been asserted. So venue can't be proper, and I object to the impropriety of a venue where there are no facts, but there's no controversy. The nature and cause of the controversy would determine the venue.
I've already agreed on that, so we're just gonna move on to the next thing.
So are you overruling my objection to improper venue?
It is the proper venue. It's in Wood County, and we've already
Yes, ma'am.
established that.
That's the territorial, yes, ma'am.
Yes, and it even gave the mile marker on your citation.
I'm not arguing anything about mile marker. I do have a problem with the judge testifying to a mile marker, or to this man who doesn't seem to work for the DA trying to testify also.
Well, when you got
She's not testifying. She's stating that the complaint, the charging instrument, lists the mile marker that's on the ticket. He can argue at trial that the jurisdiction's not sound, that this was this incident occurred at somewhere else that's not at that mile marker, but for the purposes of the prima facie case of establishing jurisdiction, she can state what's in the charging instrument. That doesn't mean that she's stating that as an absolute fact.
The citation, it has everything on it for you. You want to see the citation?
No, ma'am, I'm familiar with it.
Yeah. I mean, you know,
My
I've
concern.
told you time and time again, I want to be fair to you, and I'm trying to work this out for you.
Thank you.
And it's like every time I do something, you put out a block for me, and all I'm trying to do is help you.
I appreciate that. I'm looking for due process.
Shut up.
So, are you saying, ma'am, just for my clarity, are you saying that the improper venue objection, you're overruling that?
I've already made my ruling on
I
that.
didn't understand your ruling. I didn't hear what it was.
The venue was correct. It was in Wood County.
Well, that wasn't a matter of determination. It was I objected. So, wouldn't you need to overrule my objection?
Well, I'm gonna overrule I'm gonna overrule it then, because you're making
Okay.
this thing a whole
Okay.
lot worse than it could be. We're just trying to help you.
All right. I'm just trying to get
You're
clear
not
here.
letting us- You're not even letting us help you.
All
You're
right, so-
talking about taking us here and doing all this. I mean, why? We're just trying to help you.
We all know why.
That's all we're trying to do.
Well, Your Honor.
We're trying to make sure that we treat you right.
I appreciate
And
that.
and sometimes talking to you, I feel that I'm not.
Well, I appreciate that that's the intent. And, Your Honor, if you really want to help, I think the best thing to do is just to dismiss this. Dismiss the whole case with prejudice because they didn't start a case. That would be really simple. That would be a
Case
great
was
way to
started
help.
When you got stopped by the highway patrol.
Okay, I'm going to take exception to that.
Just like I told you last week, I am trying to help you so you don't have to keep doing this and keep running up and down the highway. But you're not trying to let me help you.
Okay, I'm looking for due process, Your Honor. I would want things to just be done to follow the law. It's just as simple as that. I'm looking for anything unusual or any special favors.
We're not trying to give you any favors.
Yeah,
We're just trying
just-
to treat you like we treat everybody else,
Thank you.
fairly.
I appreciate that. Okay, so we're going to go ahead to the next issue for pretrial here is motion for sanctions. Your Honor, I've got a motion for sanctions against opposing counsel for frivolous prosecution.
So yeah, now he's doing a sanctions against the prosecutor for malicious prosecution. I don't know why. I know why, but I'm just asking rhetorically. I'm just stating it rhetorically.
They didn't bring anything, they didn't assert anything, and that's frivolous. That's the epitome of frivolous. It's the very definition of frivolous when you don't assert anything. They're just stirring up trouble so they can get paid. They're getting billable hours for sitting here and wasting everybody's time.
You're wasting everybody's time.
It's empty, Your Honor. And I move for sanctions because it's really dishonorable to everybody here.
I need to respond to that, Your Honor. I agree, we're wasting our time here. I totally agree with that. And it's not my doing, Your Honor, it's Mr. doing. He doesn't have any pleadings on file for sanctions. I mean, it may be referenced in a notice of setting or in one of the documents, but there's not any pleadings for any sanctions about malicious prosecution or any of the other allegations he's made. There's no pleadings. There's not, they weren't properly filed, certificate of service on any of his documents. So, Judge, those issues aren't before the court properly. I don't know how to respond because I don't know what to respond to. I didn't file this case. The state of Texas did through the DPS. It's our job, and I can show you the government code. It is the DA's job to prosecute these cases. We didn't bring this case, Judge. But we're having to answer all these frivolous motions and fluff that he's bringing.
Your Honor, these motions and pleadings are before the court and have been served to Mr. Thomas. He complains that they were served to his house, but they were served at the only address that was available for really serving him. They are before the court.
Judge, if you ruled it before the court, I move that you deny them based on the fact that the DA's job is to prosecute criminal cases, and that's what we're doing. There's nothing malicious about it. We're not doing anything that we don't do in every single case.
No, Your Honor, malicious is the next one. I've got a motion for sanctions for malicious prosecution.
It's all fine.
Because he's doing this.
On my end, refresh the stream.
An intent to harm me. The first one, the one that we're on right now, is the motion for sanctions because it's frivolous. It's absolutely empty. So I'm moving right now. I would ask you to rule on my motion to sanction him for not having anything in his pleadings. He filed nothing, Your Honor.
I'm gonna deny that.
Okay. On what grounds?
I'm just denying.
I'm just denying it.
Okay, the second motion for sanctions is for malicious prosecution. I see here the motion.
Just 'cause.
I need to read off of that one. I haven't looked at it in a little while.
Guys, it's fine on my end. I don't know if you got why you guys are saying you're having an issue, but it's fine on my end. I don't know what else to tell you guys.
Getting a little mixed up with all of these papers.
Manny, I don't know why you timed BSBT. He's being a jackass, but that wasn't that wasn't something you timed people out.
If y'all have cell phones on or anything, we're gonna have to ask you to take them to your vehicles because the court clerk has raised issue with cell phones being on, sticking out of pockets and stuff like that. So we don't normally allow cell phones in here because of recording devices. So if you'll run outside and put those up for me, I'd appreciate it, per the judge.
Oh, someone got caught.
We're hearing the beeping and whatever we got in here. I'm not sure what she's going to
I said I've heard.
That was
No, it's my fault. Completely my fault. Sound off.
She just wants all the cell phones turned off and put up in the vehicle.
All right.
All right. Oh, when's the last time I turned off my phone?
They've been recording, I don't ask that. Maybe it's a sanction or something. Y'all need to have to sign all over saying no video.
Judge. Actually confiscated a little recording device the gentleman tried to bring in here and hide it from the metal detectors. We got it. It's like we're in high school, I guess.
Passing notes.
I got a recorder too, but it's all the way back home.
If you have phones, can you please turn them off?
I did.
Thank you.
He's not gonna turn them off, of course.
You're all right.
You have no idea. He's amazing.
Recorded.
Oh, I didn't see if he was. I didn't see him do all caps lock.
Turn your phones off. We can't record anything that's in here.
If he was doing all caps lock, then that's fine.
I just told him. Okay, he's gonna take your phones and put them in this box.
Sure.
Anybody that has a cell phone, just put them in this box. Yeah, man. Here's a post-it in. Mine's off.
I'll shoot the messenger. I don't know.
Here you go.
They're here,
Hands
phones
in.
going off.
Or you can take it out to your car. I feel safer in here. Here's a post-it.
Here, anything right here.
Can you hear it?
Judge, I'm gonna leave this up here so they can see it.
Yes.
Everyone, including the judges.
Yeah,
That's his legal library, Your
Oh,
Honor.
because he affects his legal attorney.
We have special favors for,
We do for attorneys, well, that's his books, that's his law books, isn't it?
he,
Yeah.
he needs to comply with whatever we're being asked to comply
No,
with.
unless the judge, no, he doesn't.
I'll do it, Your Honor.
There's a sticky note over there.
Maybe put a note on so you know your phone.
You can possibly be held in contempt.
Man,
If you're caught.
Officer of the court, I'm gonna object that he had to do that, but I'll stop there. He's an officer of the court.
You don't have your cell phone to put up.
You got it in the bottom. I put mine in the bottom.
You have a cell phone on you? You have a cell phone on you?
Cell phone.
Oh, yeah, there's no.
So you have to put it in the box.
You can't hear
for the
really, or
judge.
put it in your car.
Yeah, right in the car, you have a cell phone.
Ours in the car, yeah. It says you have to give it to the box. Put it in your car.
It's all part of your company.
document motions for sanctions, because I'm raising a judicial notice here.
More sanctions.
This honorable court will notice that to intentionally or knowingly present an insufficient indictment is frivolous. And because it is attached to so many, I mean, I've been dragged into the quicksands of court here. I'm having to show up and deal with responsive pleadings when he didn't file any primary pleadings for me to respond to. I'm being forced to stand and answer for something that hasn't even been asserted. And it's frivolous and malicious. And I move that this court would sanction them so that they won't do that anymore. If they want to start a case, they can do it properly. I'm not saying they can't start a case, but they should do it right.
All right. Last part for this hearing. I know. I can't believe there's a third part, but there is.
If they want to start a case, they can do it properly. I'm not saying they can't start a case, but they should do it right.
Mr. Thomas?
Judge, the court's already ruled that the charging instrument is the complaint, and he's denied Mr. motion that it's not. There's just really nothing for me to address here. There is no motion. These aren't properly before the court. He's made a statement with no basis in law or in fact, and he's made a statement, so ask the court to deny each one of these motions, if they're motions, and these aren't presented properly.
We haven't got to all of them. We're only on the first two.
That's my answer to every one of them, Judge.
Shall I go ahead and present, or are you going to roll on the first two?
I'm going to deny the first two. You can go ahead.
Okay. Mark that down. Denied. No grounds. Okay, the third motion for sanction is for felony barratry. Your Honor, the Texas Penal Code lays out a prohibition for exactly the kind of thing that Mr. Thomas is doing right here, which is to foment controversy and get paid for it. So I move this court would sanction him for felony barratry.
Well, Judge, again, he's got.
Barratry.
In front of the court, he's got no facts. He's got
This
no
is my
medical-
motion.
he's got
It's a
no-
verbal motion,
Mr.
it's a
Fowler,
motion.
I let you talk, let me talk.
You don't need to be talking. You don't belong here.
Ooh. This guy.
He's made no motion for barratry, he's made no allegations in any facts, he's made no allegations of legal basis for this, Judge. It is frivolous. He is filing frivolous motions with the court, and I'd ask the court to deny the motion for felony barratry.
The motion's going to be denied.
Okay. On what grounds?
Go ahead with your next one.
No grounds? Okay. My next one is a motion for sanctions, aggravated perjury, Your Honor.
Aggravated perjury.
This court has
Aggravated.
a document here, this complaint that they're saying is commencing a case. There are multiple issues here that have been lied about, and this court, unfortunately, is the victim as well as me with these lies. And I've raised the issue and showed where the lies were, and I asked that this court would sanction the prosecution here for having brought these lies. They're material facts that are before the court, such as charging instrument as a complaint and so forth, and Your Honor is falling prey to these lies that are material.
Lies.
They're material to this case. They're affecting me, they're harming me by these lies.
Okay, what is the
perjury?
favorites button?
Straight up lies, and they're harming. So he's supposed to be sworn in if he's going to testify. He's done
not.
a lot of testifying. He hasn't sworn in. I've objected to his testifying, but still, he has testified, and this court has taken his testimony as fact, even though it's inadmissible because of who he is. And I move that this court would sanction him for aggravated perjury.
Judge, aggravated perjury is a serious charge which you would have to intentionally lie to the court in a judicial proceeding or under oath. And Judge, this isn't just disparaging to me, it's disparaging to the Wood County District Attorney's Office. This is just completely disingenuous, and this is complete lies. He's basing, well, I'm not going to speculate on what he's basing his lies on, but he's not brought any evidence of any lies. He's not brought any evidence at all for this court to sanction me or the District Attorney's Office. This is all baseless, and it's made in one sentence, and it's just, I'd ask the court to deny this.
I'm going to deny
Okay. Denied.
that. What's your next one?
On what grounds?
What's your next
Browns.
Okay, the next one is for fraud. I move that this court would sanction Mr. Thomas for fraud.
Why?
He's causing a lot of harm here, and if he were following the due process of law, I would have no problem with it. But he's not, and he's trying to milk me for money, and it's not okay. So I move that he be sanctioned for fraud.
Again, no factual allegations. He doesn't even tell the court what fraud is and how I'm supposed to have committed fraud. He simply says I committed fraud. And he says I'm milking him for money. Judge, there's no basis at all in that. I don't know what he's talking about.
Bear in mind that if this guy was an attorney and making these accusations and claims in open court, he would be actually up for sanctions and discipline.
Out there, and it's gotten to the point where I'm going to keep my mouth shut and ask the court just to deny that motion.
These are the companions, yes.
What's your next one?
Okay, next one was a dispositive motion to dismiss for lack of or failure to show lawful invocation of jurisdiction.
Oh my God.
And, Your Honor, you've already ruled on the underlying issues for this, so.
So why are you bothering?
Denying this motion as well?
Yes.
You're saying that jurisdiction did get invoked?
Yeah. Moving on.
Okay.
Wait, what is this building?
The denial
This is new.
Of all 7 of these issues here. And I reserve my right to take that to petition for interlocutory orders. At this point, I have a motion before the court that is for Mr. Thomas to show authority of counsel. I have a sworn motion that says I believe he doesn't have the authority to do this, and I need him to show authority. This court has no discretion as to whether or not to just make a decision on him having authority until that there's a hearing and the burden of proof is on him. as outlined in my motion.
If, without him presenting that motion, what I remember, the motion is based on the rule of civil procedure. The rules of civil procedure don't apply. First, they don't even apply, other than a few exceptions, they don't apply in justice court. And the rules of civil procedure sure don't apply in a criminal action in justice court. But despite that, I have a response to that. It's in the government code, section 44.350, where the legislature has laid out in every county the responsibilities of the district attorney's office. And it specifically says Wood County, 44.350, Wood County. Subsection B says the criminal district attorney shall attend each term and session of the district courts in Wood County and each term and session of the inferior courts of the county held for the transaction of criminal business, and shall exclusively represent the state in all criminal matters before those courts. That's our authority, Your Honor.
Your Honor, he's talking about something that's not before the court. He's talking about whether or not the DA would have authority. He is not able to show, or let's ask him to show, because the burden of proof is on him, that he does have the authority. And by that I mean he needs to show he's even with the Wood County District Attorney. That office has repeatedly told me they don't know who he is. So for him to come in here, are we going to just listen to anybody that walks in off the street and has a suit?
Oh my God.
It is not proved out of the mouth of the agent. It's proved out of the mouth of the principal. So we need to get somebody to say he has authority. And that wouldn't come from you, that would come from the principal. He supposedly represents the state of Texas. How are we going to get the state of Texas to come in here? The district attorney? I don't see anybody that says that he is an agent. In fact, the opposite, Your Honor. The DA, out of the mouth of the DA staff, they say he's not. Or that's what they've told me. So I have reason to believe that he doesn't belong here.
He's a special prosecutor for Wood County.
Are you testifying?
Judge, in addition, this whole motion is based on the rule of civil procedure, and that does not apply in a criminal proceeding in justice court.
Your Honor, in any case, whether he believes that civil apply or not, in any case, it's axiomatic that we can't have somebody come in here and pretend to represent somebody. It has to be proven from the mouth of the principal. Civil, I don't care if it's water code, utilities code, copyright infringement. Somebody can't just walk in here with a suit and say, I'm going to prosecute this. I have reason to believe, and I do believe, that he's impersonating a public official. Now, whether the Wood County DA has the responsibility, the authority to prosecute certain kinds of cases, that's not before. I'm not arguing that anymore. I did argue that. You ruled on it. I'm not touching it anymore. We'll see what the appeal court has to say about it. But this issue is about whether he works for them. Whether he can show, did you bring any evidence to show this court that you are authorized? That's what I'm asking you.
No response, Your Honor.
Burden of
It's
proof
not
is
my
on him.
job- Not my job to have a burden of proof on this motion, Your Honor. So he's provided no basis at all.
Your Honor, the basis is right there in the motion. I've laid it out. It says the burden of proof shall be upon the challenged attorneys to show sufficient authority.
Mm-hmm.
Judge, that's
Well, that's
pursuant to a rule of
obviously-
civil procedure. That's not.
Are you
anything
interrupting?
in the Code of criminal procedure.
Are you?
Obviously, it has to be somebody proving it from the mouth of the principal, not the agent.
Okay, I appreciate the faces on this in this mod list.
No, ma'am.
Do you have anything else?
No, Your Honor.
Okay, all right.
On that motion, you mean?
You have anything else?
Nothing else on that motion, but I still do have the rest of the pretrial issues there before the court. Can you issue a ruling on that one, please?
It's denied. He is he's a special prosecutor that we know of.
Okay,
I don't know
so,
why the people that when you call, they don't know who he is.
okay, so I'm gonna take that as the motion for him to show authority is denied, and that the grounds are your testimony from the bench.
Oh my God. No, dumbass. No, the trial isn't 6 parts. It's 4 parts. I apologize. Which doesn't
Okay.
sound that much better, but it's 4 parts.
I raise an exception to the judicial error of Your Honor testifying in that. And I do intend to petition for an interlocutory order on that as well.
Yeah, of course you are.
The next issue I have is also dispositive. It's a motion to dismiss for baseless cause of action. That one, let's see here. There it is. Do you have a copy of that one? So, Your Honor, this motion was filed on the 12th of September, and I'm asking this court to dismiss this case. You said you're trying to help me out. Well, this cause of action is baseless, so it's the perfect thing to help somebody out with, because here we have nothing brought before the court. It's in violation of procedural rules. He swore to follow those rules, and he's not. Well, I presume he has. I shouldn't say he swore. I'm not really sure, Your Honor, if he swore or not.
An interlocutory order. Well, what he should be saying, in my opinion, should be an interlocutory appeal. An interlocutory appeal is an appeal that's made by a party when the case has not been decided yet on the merits. So in other words, say that somebody files an evidentiary order, like there's an evidentiary hearing, right? And the judge rules that the evidence is suppressed. Well, the prosecution can file an interlocutory order to challenge the judge's ruling on suppression of evidence, because the evidence suppression isn't the merits of the case itself. It's part of the process. But filing an interlocutory appeal means that you're challenging that, even though the actual case itself has not been fully decided.
I do know that he's violating the rules, but I'm not sure if he swore. Does that make sense? Okay. Nothing in particular has been alleged relating to any offense. The DPS has on their e-filing something about 10% speeding over, whatever, but they didn't allege any facts. No ultimate evidentiary facts. So it's baseless. There's no way for anybody to find. You have to apply the law to the facts, and there aren't any facts, so it's baseless. It says here, no ultimate evidentiary facts have been alleged in support of essential elements of any offense. No ultimate evidentiary facts have been alleged in support of the inferences being reasonably drawn. No ultimate evidentiary facts have been alleged that would entitle the claimant, if there is a claimant, to any relief at all. No reasonable person could believe that relief is due without any pleadings of fact whatsoever. This honorable court should justly decline to wrap a cloak of legitimacy around the instant frivolous and malicious prosecution I understand that you don't find it that, but you should decline to wrap a cloak of legitimacy around it because it's patently baseless. It's simulation of legal process, Your Honor. There are ways that they can do this and do it right and do it according to the law. They're skipping all of that and pretending and bluffing and faking, and they have nothing. They have literally presented zero. So I move that it be dismissed for being baseless.
Denied.
On what grounds?
On what grounds? Denied.
All right, I raise an exception to that.
Of course you would take exception.
And it was unopposed and denied with no grounds. Exception. All right. Next up, I have a judicial notice.
Judicial notice
Number
now.
one was that 0 facts were alleged in the pleadings.
Oh my God.
Take judicial notice of that.
No.
Oh, maybe he could show us some facts, Your Honor.
There's the complaint, and if you want, I can respond to that, or we can wait. But I object to you taking judicial notice of it.
Take a look at the complaint, Your Honor. That's his only horse to ride, and he's acting like it, that this judicial notice should not be taken. Well, it's in the record. I would just ask that you take note that there are no facts in it.
May I respond, Your Honor? Your Honor, Article 45.019 of the Code of Criminal Procedure, and I apologize for having to take up the court's time reading all this. A complaint is sufficient without regard to its form if it substantially satisfies the following requisites. Number one, it must be in writing. This complaint is in writing. Number two, it must commence in the name and by the authority of the state of Texas. This complaint begins with those words. It must state the name of the accused, if known, or if unknown, must include a reasonably definite description of the accused. It names Mr. It must show that the accused has committed an offense against the law of this state, or state that the defendant has good reason to believe or does believe that the accused has committed an offense against the law of this state. The complaint does that. Number five, it must state the date the offense was committed as definitely as the offense is able to provide. It gives the date. Number six, it must bear the signature or mark of the offense. It bears his name and his signature. Number seven, it must conclude with the words against the peace and dignity of the state, and if the offense charged is an offense only under a municipal ordinance, it may also conclude with the words contrary to the said ordinance. The complaint in this case concludes with the words against the peace and dignity of the state.
Your Honor,
45
objection, relevance.
Goes to the whole argument he's made, Your Honor.
We're not
45
talking about the sufficiency of a complaint. He's
Fountain.
wasting everybody's time. You've already ruled on that, Your Honor. This is not about sufficiency of a complaint. This is only about, will Your Honor please take judicial notice of the fact that the complaint doesn't contain facts. Evidentiary facts are not in the
And
complaint.
that's what this
He's
response
talking
is.
about sufficiency of a complaint and trying to paint it in some way that makes it sufficient, but Your Honor has already ruled on that.
But the determination of what is or is not factual is for trial. Again, a lot of these guys think that these pretrial hearings are supposed to be trials on the merits. They don't understand that, or that they do. They're just being, obtuse, and of course they're just doing it to make a mockery of the court.
Your Honor said it's sufficient.
Yeah, and
We sure
the chutzpah on this guy to say that the prosecutor's wasting everybody's time.
Asking
Danny mentioned that.
to find that the complaint's not sufficient.
No, Your Honor, that's not what I
I'm
said. I asked you to
There's no-
take judicial notice of the fact that there are no evidentiary facts in the complaint.
Judge number B on that
Okay.
same article says a complaint filed in justice court must allege that the offense was committed in the county in which the complaint is made, and it does that. So those are the only facts to establish probable cause. We're not to the trial yet, Your Honor. There's not any facts that need to be alleged beyond a reasonable doubt. That's for the trial. So his arguments here are baseless.
Your Honor,
Exactly.
they're not baseless, and here's why. There's a four corners doctrine.
Oh
When
my-
he wants to put
Four corners. Why are we invoking contract law?
some pleading into the record, or he wants to pretend like he's the one that put it in there because it came from DPS. There are four corners on that document, and he can't prove anything that he didn't allege. There's nothing, Your Honor. I have the presumption of innocence, and if he brings nothing to the table, then there's nothing to go to trial with. There's nothing to answer, because there are no facts. Nothing has been alleged.
God! The facts are borne out at trial.
When he wants to allege something, and you know, he can do this in the future on other issues, he can allege something and put facts in there and say that the accused is believed to have done X, Y, and Z, and therefore I have reason to believe that he did this offense. But if he's going to try to go forward with this, there's nowhere for him to go because he hasn't alleged anything. He can only prove what he has already alleged within those four corners. And Your Honor, you have already ruled that that's the charging instrument.
Mm-hmm.
So he has nowhere to go with this. It's empty.
Judge, I'm not going to take up the court's time with the law. This is the charging instrument. It's the probable cause. It's all that's needed. Mr. confuses a complaint and a Class C misdemeanor with an indictment and a felony. Those are apples and oranges.
We're not talking about that anymore, Your Honor.
Judge, those are apples and oranges. This complaint that is in this case that's been filed, that is the charging instrument, complies with Section 45.
Objection relevance.
Complies with Section 45019 of the Code of Criminal Procedure.
Your Honor, we're not talking about that anymore. He talks about not wasting the court's time while he rehashes everything that's
Oh my God.
We're talking about taking judicial notice of the fact that there are zero facts in that document that he wants to say is the charging instrument. Your Honor, you have ruled that it's the charging instrument. Nobody's arguing.
If they were going to rule those as facts, what's put down in the complaint as factual, then there wouldn't be a trial. He would be adjudicated guilty already. If the judge were to rule that everything in the complaint is factual.
That anymore right now.
They're allegations.
One thing is, take judicial notice of the fact that it's empty. There are no evidentiary facts there.
And I oppose that request, Your Honor, that there are the facts in there
Okay.
for the basis of this complaint.
Anything else, Mr. Thomas?
No, Your Honor.
Anything else?
No, ma'am.
I already agreed that that's a charging instrument,
Mm-hmm.
so your request is moot. And
I'm not asking about charging instrument. I'm asking you to notice that there's no facts in there.
okay, I'm gonna deny that.
Oh.
There is. Okay, I'm denying
Okay.
that. What's your next one?
Next up is, well, first I'd like to take exception to the judicial error of not taking judicial notice of something that's clear as day in front of everybody's face. I raise an exception. Nothing personal, Your Honor, at all. But
But he's going to end up filing recusal, a demand her recusal, and I don't know if he submitted a grievance to the Judiciary Committee against this judge, but I know he did the grievances to the attorneys.
I
though.
just have to preserve the error for review. Next up is dispositive also. I move that this court would dismiss I move for a summary judgment and a dismissal. It's a no evidence summary judgment.
Mr. Thomas, do you have anything?
Judge, I just asked Mr. Sawyer, because I don't want to be accused of misleading the court, but I've never heard of no evidence summary judgment for criminal cases, but those are normally in civil cases. But
Yeah, no, the summary judgment. What is he talking about?
there's been
There is no summary judgment in a criminal case.
sufficient evidence to find probable cause to proceed in this case. Just ask the court to deny that motion if there is such a motion in criminal law.
Your Honor,
Fuck your table set.
if there's no evidence, then there is no basis
yourself
for
a bar.
finding what the subject matter is. He keeps saying the word criminal and acting like criminal, but without any primary pleadings, this court has nothing to latch on to determine what is the nature and cause of this case. So, yeah. there's no
Nature and
evidence,
cause.
so I'm asking for summary judgment. Okay. On what grounds?
We don't have any information on the summary.
Okay. I raise exception to that denial.
We know.
I need to raise an exception, Your Honor, to the due process abrogation of having a complainant, a DPS trooper, be a filer in this case. Normally, we don't just allow any random Joe to come in here and stick things in before the court and call it a case. He's a non-party. I presume that that Mr. Thomas, if his office were doing their job and getting all of the documents lined up to start a case, they would call him in as a witness. But he's not a party. They've been trying to blur this line and say, "Oh, state of Texas, state of Texas."
But he's a witness. That's fine.
But Your Honor, he's not a party.
He's the affiant.
No business filing.
Oh my God.
Here. If someone were to file something, it needs to be the DA's office. They need to take his complaint, they need to draw up an information based on it, and they need to file both of those into the record from the DA's office, Your Honor, not from the DPS. So I raise exception to this court acting like there's a case.
Michael, do you actually know who this guy is? If you do, I would very much would like to know, and you can reach out to me in Discord if you're part of it.
That was filed from a non-party.
Judge, my response on that is
You don't have to tell the name here.
authority to even make that request, so ask the court to deny that.
That's gonna be denied, sir.
Exceptions aren't denied.
And if you just make an exception and deny, talk and just move on.
Now, this is in Texas.
So, let's see.
That was the last motion before the court, wasn't it? That was the last motion that you had for us.
I have some more things.
Judge, if they're not before the court, I would reject it.
Yeah, we don't have anything else before the court.
I don't know. I am looking at my checklist here and not looking at what's before the court. However, I would remind the court that in a pretrial, I can bring things orally or verbally. I mean, orally or in writing. It doesn't have to be something that is already before the court, and it clearly states that. I have, let's see, I raise an exception to the clerk failing to deliver an indictment or information. That's a due process requirement. I raise an exception to the prosecutor suppressing facts that establish my innocence. Those facts have been suppressed, Your Honor, and I raise an exception.
Judge, I'm gonna have to ask what in the world is he talking about there, because he can't just make allegations such as that with the court and expect me to sit here saying I've suppressed something. I'd like proof of what he's talking about there.
No, I stand on it. I'd also like to raise an objection to the prosecutor ostensibly attempting to prosecute a case that hasn't been commenced.
Oh my
They're
God.
two different things, Your Honor. A little while ago, Mr. Thomas, acting like he's speaking for the DA, referenced the Government Code 44.350 and referring to a duty that the DA would have to deal with criminal issues. However, that's prosecution, and this case has never commenced. We can look at, there's nothing. I object to him prosecuting prior to commencement.
No response, Your Honor. That's been addressed by the court.
Are you overruling that objection? You're sustaining the objection? I objected to the prosecutor ostensibly attempting to prosecute something that hasn't been commenced. There's a due process commencement, and he hasn't done any of it. So while there may be a complaint, and it may be sufficient as a complaint and all this, he's trying to prosecute something that he's missing some steps. He hasn't got to the part about prosecution. He's still on the part about commencing, and it hasn't happened yet. So I objected, and I'm looking for either you sustain the objection or you overrule the objection.
I've already ruled on that complaint. I've already ruled earlier on that complaint.
I'm not talking about the complaint. I'm talking about the commencement needs to happen before the prosecution. He's trying to prosecute.
We're just right now trying to establish why we're still here.
It's a great question, Your Honor.
Do you have anything else, Mr. Thomas?
No, Your Honor.
What else do you have?
So is that overruled?
This guy.
That objection is overruled?
Yep.
Okay. On what grounds?
Grounds.
Go ahead, you have something else?
No grounds. Okay. Yeah, next was going to be a motion to sanction him for prosecuting prior to commencement. That sounds like you're not really inclined to do that.
My only response there, Judge, is what authority is that sanction referenced. He gives no legal authority for that, so I'll stop there.
Denied. All right. And on no grounds. Well, I raise an exception to the due process abrogation of having prosecution prior to commencement. Let's see. I have a motion to suppress, Your Honor, that's before the court. It's to suppress illegally obtained evidence as inadmissible.
What evidence?
I'm sure, Your Honor, you're familiar with the exclusionary rule, and
This
evidence was illegally obtained.
What?
Evidence that is before the court that's saying such and such happened at such and such a place. Well, actually,
What?
they didn't say such and such happened. They just said such and such a place.
What?
Even that much was inadmissible because it was collected illegally.
Huh?
So, and I think that's also before the court.
In what manner?
in written form.
How? In what? That's a declaratory statement. In what way was this? You weren't even specific. In what way was this evidence collected illegally? You can't just say that.
Do you have anything, Mr. Thomas?
No, Your Honor.
Mrs. Sawyer, do you have?
How is he supposed to respond to that?
Judge, as far as a motion to suppress goes on a Class C misdemeanor, my understanding of the law is once the complaint.
Objection, relevance. It doesn't matter what he understands. He needs to bring the law or...
Oh my God, shut up.
Judge, that same argument can be brought to Mr. He's brought no law, he's just bringing argument in here. He's brought no basis and legal basis for any of this. So I'd ask you to allow Mr. Sawyer to complete his
Go ahead,
statement.
Mr. Sawyer.
The complaint is sworn to under penalty of perjury.
Oh, this guy.
by the officer that charged Mr. Brown with this offense. My understanding is that in a Class C misdemeanor, like this is that once we have done that, if Mr. Brown wants to try to suppress something saying it was seized illegally, the state has shown at this juncture of the proceeding that it was all done legally. At that point, I believe the burden would shift to Mr. Brown to show that it was done illegally. So the onus would be on Mr. Brown to subpoena his witness and bring evidence, which he has not done.
You have anything else, Mr.
Yes, I object to his...
You gonna fight me or not?
Law, just making it up right now, just pulling it out of nowhere.
Wuss.
And trying to convince this court that the burden of proof is on me. He brought nothing. Just he says, I understand and I believe, and that's not going to be able to sway the court, or shouldn't be able to.
And your misapplication of the law is supposed to be taken as gospel? Just because you say it with confidence?
Nothing further, Your Honor, from the state.
Not so sure about that.
Okay. On what grounds?
Judge, just so the court's aware, the court does not have to give Mr. any grounds for its denial.
Go ahead, Mr. with your next.
I raise an exception to the very idea that a ruling could be groundless. And I raise an exception to inadmissible hearsay not being stricken. It needs to be out of the record if it's inadmissible. I've called it inadmissible, I've objected to it, and I've showed how in my pleadings. So for it to be treated as admissible is harmful to me, and it unduly extends all of this burden and cost of being here. So I raise an exception to that. I have a motion to dismiss here that I'm not going to address right now. And
Judge, the only response I would have to that is this is the pretrial hearing, and if he intends to bring that up in another pretrial hearing, this would be his opportunity to bring up any motions, pretrial motions.
Your Honor, we're only here because he wasn't prepared for the first one. This has been in the record since prior to the 20th. We had a pretrial scheduled for the 20th, and he wasn't prepared for anything, and he lied to the court about the purpose of a pretrial. So for him to come in here and say that we need to hear everything right now is highly inappropriate. We have the motion that I did not want to address right now, Your Honor, is because it would be a waste of time. This court has already ruled on the underlying issues regarding that, and it was connected to, my motion to dismiss was connected to the witness which the accuser has failed to bring, if in fact there is an accuser. I continue to note that there is none. But he failed to bring a witness. Your Honor, the chair is empty. There's nobody to call up. So my motion to...
Why would the witness, aka the officer, be here? This is a pretrial. It's not trial.
dismiss based on my firsthand personal knowledge being greater than his unsubstantiated belief, as seen in the complaint here. It says, I have reason to believe, and I do believe. Well, where is he? His unsubstantiated belief is lesser evidence than my firsthand personal knowledge, Your Honor. So I was going to move that the court dismiss based on that. You want to hear it right now? There it is. You want to oppose it?
Judge, the state opposes Mr. request for set for pretrial, not trial. It's moved at this point. It's not like.
Your Honor, I would ask that this court take judicial notice of 2801 of Code of Criminal Procedure, in which it states that this is the time to deal with that.
Judge, Mr. is correct, the burden of proof is on the state to prove the allegations. However, the notice to the state for today, October the 6th of 2022, is for a pre-trial matter. We are not set for trial. At the trial setting, the state will present their witness against Mr. Fountain and prove his case.
Exactly. What he said right there is exactly what I just said. That this is a pre-trial, not trial. Once we're at a trial, then we're going to bring the witnesses that we have prepared. Again, these guys think that they can jump 3 steps ahead.
Your Honor, I would make another side note here that this man, Mr. Sawyer, has not been sworn in, and he's over here trying to testify.
He's not testifying.
That's not what the law says.
My God.
We have, as I've just asked you to take judicial notice, a pretrial does cover this. It's in 2801.
Judge, I would ask Mr. Fountain to be specific then in what section that he's talking about.
Would you like me to?
Sure. It's right here.
I also really hate the fact that he's involving his kid in this.
Okay. We have 2801, pretrial. The court may set any criminal case. Well, I'll skip on down to the part where it says subsection 2. This is the pretrial hearing shall be to determine any of the following matters. And subsection 2 says pleadings of the defendant.
Oh my God, mudcrap.
I have a pleading to move to dismiss. It's a dispositive motion. If you want this to go away quickly, you want to do everybody a favor, you can rule in favor. You can grant my dispositive motion, which actually, now that I think about it, is even stronger since there's no witness.
And there's no requirement in 2801 for the state to bring any witnesses.
However, there is a requirement for...
Pleadings are not evidence in the first place. So
Pleadings are not evidence also.
his request under 2801 is baseless.
It's not baseless, I just showed you.
Told.
Your Honor.
Oh my God.
Where we're going
Told
with
not.
this-
The kid corrected him. I just told not showed. Yeah, that's exactly what he did. He only just said so. He didn't show anything. His kid corrected him.
There are a lot of policies, a lot of customs, patterns, and practices that happen in a prosecutorial office that are not backed up by law. And I'm looking forward to fixing that with your help.
Are
This
you?
can be fixed for the sake of justice, for the sake of Texas. We can have a prosecutorial office that follows the law, and it'll be so much better for the people. I understand that these policies are in place.
And now he's pontificating. These guys love to do that.
I realize that it's what they commonly do, but I really would like to see that come back in alignment with the law, Your Honor.
Brief response to that, Your Honor, is the policies, the only policies the Wood County District Attorney's Office follow are the law. So I'll leave it at that. He's intimating that the office does not follow the law, then he needs to prove that. And we can do that at trial if that's what he wants.
You have anything else, Mitch?
No, just looking forward to your ruling on that motion to dismiss.
I thought she already. I thought she already did rule it, but
Any grounds for that?
probably like the 45th motion to dismiss, I guess.
Okay. So, I move to strike the complaint, Your Honor. As
Of course he does.
Obviously, it's hearsay, which is perfectly fine if we were doing the examining trial, but as you have already noted, you will not grant an examining trial. That would be the appropriate place. In the examining trial, it says that I get to cross-examine my witnesses. And that would
No, you
be
don't.
when it could get promoted. Before this court, it could get promoted from mere hearsay.
Well, maybe you can, I don't know.
Just enough to try to find out, do we have probable
But again, once again, we're relitigating something we already talked about in the previous hearing. He's doing it again.
cause? It could get promoted by his testimony to the level of, I find probable cause. Based on an actual conversation, he's not here. So you can't really, I can't face my accuser. I can't cross-examine the witnesses, which is
What we're doing at trial.
exactly
That's
what it
what the
says.
trial will be for.
Exactly.
We couldn't get anything resolved today.
We could do that
The
too.
trial will be for you to see the trooper that is your accuser.
We could do that
You'd
too.
be able to question him.
No, he's not the accuser. He would be the witness, ma'am.
Well, I'm sorry.
Well, he is. You're right.
And,
That's the one actual correction you got to correct. The trooper's the witness. The accuser is the state.
and you can ask him whatever questions you want to ask him.
Sure.
And hopefully you'll have seen or received the video. However, the DA's office will release the video. We're going to try to get that done.
It sounds like you're predisposed. Correct me if I'm misunderstanding you, but the way you're talking, it sounds like we're going straight to trial. And
Are we not?
Well,
you
it
may
doesn't
have
seem like
already
we're
decided.
No, it doesn't seem like we're getting anything done today. It's almost 12 o'clock.
Yes, ma'am. I didn't get my breakfast, so I'm looking forward to this being over as well.
Yeah.
But I feel like
No, I'm not rushing you at all, but
Okay.
I don't want you to think that I don't want you to be treated fair and get your day in court.
Mm-hmm. Well, as it is, I mean, I'd be happy to have a day in court if they had followed due process, but they haven't got that. So I'm preserving the error so that an appellate court can review the fact that they're not following the law. And I'm totally comfortable with doing that. That's okay. And, you know, if it comes to having a day in trial on some other issue that somebody wants to accuse somebody of, well, that's fine. But right now, what's before the court is a motion to strike the complaint as inadmissible. Here we have hearsay, Your Honor. This complaint says at the top of it that the undersigned has good reason to believe and does believe. Well, that's hearsay, Your Honor.
Okay.
That's-
I would deny it, saying that the complaint is a piece of evidence to show it's a probative piece of evidence, number one. Number two, I would say it's not necessarily to be shown for the truth of the matter, not being provided for the truth of the matter asserted. In other words, it's not being provided to show that he did in fact speed on this day. It's only simply to show that a complaint was written accusing him of this violation.
Inadmissible, patently inadmissible. Per the Texas Rules of Evidence, it can't be evidence here today. So
I don't think that they
I
even
wouldn't be stricken.
would bring it in as evidence in the first place,
based on the fact that it's inadmissible hearsay.
except
Technically,
to show that a
it's
complaint
not
was
even a matter of
filed
discretion, it's just
against him.
needs to be stricken.
Anything else? Mr. Thomas, Mr. Sawyer?
Just real brief. I'm researching and reviewing chapter 543 of the Transportation Code, and it's arrest and charging procedures, notices and promises to appear. Any peace officer, and 543.001, any peace officer may arrest without a warrant a person found committing a violation. of this
Objection,
subchapter.
relevance.
Shut
543.
We're not talking about transportation code.
543. Your Honor, he's complaining.
We are talking about the transportation code. That's the code that you were cited under.
Complaint not being sufficient or alleging.
No, I'm
Complaint. Facts in the
asking, Your Honor,
Judge, may
I'm
I
asking that
proceed?
this be stricken because it's inadmissible. Not
Oh my
because of
God.
anything about the transportation code.
Shut
It's
up.
hearsay. It's a simple matter of looking at the rules of evidence and saying, look, it's hearsay.
Judge,
Oh, that's
he's saying
inadmissible.
there's no facts in the complaint. The complaint is a sworn instrument, and I'm trying to let the court know everything that occurred by Trooper Nichols was by the book, and I have the law here to show it. If the law is getting in the way of his argument, then I can't help that. 543.003, notice to appear required. An officer who arrests a person for a violation of this subtitle, punishable as a misdemeanor, who does not take the person before a magistrate, shall issue a written notice to appear in court, showing the time and place the person is to appear.
Your Honor, I don't know why he's
If
talking about all
charged,
this.
the name of and address of the person charged, and if applicable, the license number of the person's vehicle. All of this was done by Trooper Nichols. That's in the citation and.
He's testifying. I object to his
An officer
testifying.
shall issue, 543.004. An officer shall issue a written notice to appear if the offense charge is speeding.
Your Honor, nobody's talking about whether or not he has the authority to issue a notice to appear. That's not before this court. A notice to appear is not the same thing as what we're talking about right now. The fact that a complaint that's hearsay is inadmissible.
Judge, a complaint is required. It's the charging instrument. It's required. You've already ruled on that.
Yes, Your Honor has already ruled on the fact that a complaint is a charging instrument. However, this particular complaint is hearsay. It specifically references his belief as opposed to him saying, I have personal first-hand knowledge of something, which he never said anything happened. So it would be moot anyway, but he is saying specifically here that it's based on his belief. And he's not here to back it up, Your Honor. It's inadmissible, straight up per the rules of evidence.
Well, it's a good thing that when we go to trial, when he's a witness, then we can actually talk about it. And then he can probably strike
You
it.
have to strike it.
No, he doesn't. She doesn't have to strike it at all.
Okay. On what grounds?
Go ahead with your next.
No grounds.
Okay. Let's see. I raise an exception to inadmissible hearsay not being stricken. There's another issue that needs to be brought up, Your Honor. I'd like to make ask you to take judicial notice of the fact that your court clerk here has impersonated a judicial officer. when
Wait,
she
what?
Forged a vicarious plea.
What?
Judge, I'll object to that request.
I'm still talking.
He's saying that there's facts. There is no facts.
I'm still talking. There was a plea entered on my behalf.
Ha!
I didn't
Oh,
enter.
he mad about that
Somebody
one.
said, not guilty, we should go to trial. I didn't
Yeah.
say that, Your Honor.
Judge, that's the law.
My
That's the
plea-
statute that-
my
that
plea
you
was
won't
already-
enter a plea.
Will you please be quiet?
No, I won't.
No.
That's statute.
So, I'm
He doesn't
talking.
enter a plea.
Already we're getting, so yeah, now we're getting testy. I mean, obviously, honestly, I'm surprised it hasn't gotten this bad already. But now these two are starting to get, and I'm not a big fan of the judge here. Luckily, there's going to be a different judge for the trial, but I haven't been a big fan of I'm not a big fan of this judge. She's just been frankly letting both parties roll over her, but largely the defendant more so than anybody else. And she's really not getting a handle on the court right now.
And I have this I have an exception before the judicial notice before the court here that a plea was entered. I'm not asking you to rule on whether or not you like his interpretation on whether she's allowed to. I'm just asking you to take judicial notice that she did.
Judge, and he's saying Ms. Riggs, she didn't enter that plea. The court did on my request pursuant to Texas law.
That's very interesting, Your Honor. On his request, I never got a copy of that pleading, so I would ask that you sanction him for not following Rule 21A and giving
Oh
him
my God.
an opportunity to oppose that request.
Your Honor, Mr. appeared at that hearing. It was a verbal motion to the court, and it was based on Texas law, that if he won't enter a plea, one will be entered for him of not guilty.
All right, Your Honor, I think we need to take a look at this refusal then, because He's orienting everything around a refusal, and there was no refusal to plea. I already had a plea. It was already there, and somebody put a plea in of not guilty. My plea was 2702 subsection 1. I have an exception to the charging instrument. That was my plea. Somebody switched it, and somebody said not guilty, you need to go to trial. Your Honor, I'm asking you to take judicial notice of the fact that somebody switched it and said we need to go to trial.
Your Honor, you taking judicial notice of a fact has to be undisputed in fact that you can take judicial notice of. That's not a fact that you can take judicial notice of.
So the fact is, the undisputed fact, somebody said not guilty is my plea, and we need to go to trial. The only way things process on and go towards trial on the merits is if everything else is all handled and somebody actually got charged with something and somebody answered the charge and said not guilty.
Okay, go ahead, I'm listening.
No, that's it. I just wanted you to take judicial notice of the fact that that happened.
Anything else, Mr. Thomas?
No, Your Honor.
Mr. Sawyer?
Just ask you to deny his request, Your Honor.
I'm gonna deny that.
I'm starting to see a pattern here.
Oh, now he's mad. Hey, Scott, thank you for the 20 months. Of course, I can never forget them. They'll never let me forget them.
I'm gonna ask that everybody on the outside, please be quiet, not trying to be rude to you. I know it's just habit, it's okay, but, we can't have that.
I didn't hear anything. Let's see. I do have one more exception I'd like to bring before the court, and that is
Yes, sir.
the court's refusal to set aside this imaginary indictment or information.
Oh my God.
I realize that you've already ruled on the sufficiency of the complaint, but I just want to make sure that that's preserved for review. Is that the court is not going to set that aside.
Judge, my response, there is not an indictment, there is not an information. There is a complaint, which is the charging instrument, as I've already referenced, pursuant to case law. That is the charging instrument. There's not an indictment, there's not an information.
And at this point, the only thing I have left, Your Honor, is a motion to disqualify you, Your Honor.
There it is.
Refusal to perform your duty. I'm seeing bias and prejudice. I'm seeing that you already have an interest in a strong partiality, and I feel like I'm not going to be able to get a lawful ruling in this matter. So I move for your judicial disqualification.
No.
Nothing personal.
You want another judge to sit on there?
I want you to be disqualified.
Judge, there's absolutely no reason for you to disqualify yourself. You've been unbelievably patient, fair, courteous.
Exceedingly patient.
Held Mr. in contempt. To me, shows that you have the patience of Job.
Ha!
You absolutely do not have to disqualify yourself. Every ruling that you've made today has been proper and has been correct. Mr. interpretation of the law is not what the law is. If he has an argument with that, he can follow it and try to appeal it. I'd be interested to see how that goes for him. I'm asking you to deny his request, disqualify yourself, and we need to proceed to trial.
Your Honor, just as a quick little note here, that motion is not something for you to deny. That's something for you to refer to somebody else to deny.
Judge, I'd like to see the basis of that, what he's saying there.
I'm not.
Well, that actually depends on the jurisdiction. Some jurisdictions allow a judge to determine their own disqualification, but as we know from the Blandino saga in Nevada, that's not the case.
Hearing this man, he doesn't know the law, and he you need to rule on that motion, regardless. You need to not rule on that motion regardless. If you would like for me to tell you, I'll tell you. But I'm not going to tell you. He doesn't belong here.
Oh my God, I'm surprised the attorney hasn't
The basis.
ran over to the other table and started throttling this guy.
Whatever you want to say. We've been-
Okay. So, my basis for that would be Texas Constitution, Article 5, Section 11, and Article 5, Section 1-A, and Texas Government Code, Section 27.055, and Texas Local Government Code, Section 87.011, subsection 3, and Texas Local Government Code, Section 87.012. And
I haven't seen these yet, so I honestly don't know.
Your Honor.
Like I said, depends on the jurisdiction.
Mr. Sawyer,
That's the advisory request, Judge.
what request is going to be denied?
Grounds.
On what grounds?
There it is.
We're going to be adjourned at this time.
On any, no grounds? Okay.
Thank you, everybody. And hope you guys have a good day. Safe travels home.
It's over.
Remember to get your phone. Tell Mr. Kelly.
Uh-oh.
Did you get taller so much while you left? You want some drink?
You need help getting things together?
Yeah, that would be great. Just kind of stack it over here on the red. Were all of these people came?
Yes.
All those people too?
The other ones left because the daughter had law class.
Wow. Law class.
Mm-hmm.
I bet this was interesting for
Yeah.
her.
I've stacked everything separately in order. I don't know if you want to switch around or not.
Mr. Sawyer, could I get some kind of contact information from you? Your email, your fax?
The DA's office, my email, I can give you my email.
Okay. Yeah, just, I mean,
All right, so that I'm not gonna let that keep on going. We're all done. It's all done for now. All right, so yeah, so on November 29th, we eventually go to the actual trial. Sadly, I will tell you ahead of time in the first half hour or so, he does his best to relitigate almost everything that he's tried to argue here. If he does, I promise I'll try to skip through most of that so we can actually get to the actual trial itself. So I'll go on. So we're gonna listen to this trial on Friday. As always, I'll be off stream on Thursday. And yeah, like I said, it's gonna be one of those things. Yeah, I know, but I want to keep these parts concise. But honestly, at this point, I don't even know if people even want to come and listen to this crap. But all right, thanks guys again for watching. As always, it's always appreciated. I hope you have a good rest of your day. Hit that like button on the way out. Join my Discord if you haven't already, and I'll see you next time. Thanks, guys.